name is Vincent Kruse, and it is my great privilege this morning to introduce our distinguished speaker. I have been given this great honor because I had a very important role in the creation of this book. When the author was thirsty, I would bring her some juice. And when the author was having a hard time coming up with the ideas for the book, I would bring potato chips. Back to the matter at hand, the author is here today to launch her first book, entitled The Pacific Insular Case of American Samoa, Land Rights and Law in Unincorporated U.S. Territories. As a daughter of Laie and product of this very institution, she has fittingly chosen to begin introducing her book to the world by starting at home, amongst close family, dear friends, and respected colleagues alike. Her book is a scholarly study of land issues in American Samoa and how historical changes in American Samoa's laws in the last century have impacted Samoan native land tenure. The information contained in this book is the product of archival research of both primary and secondary resources located in American Samoa, the independent state of Samoa, New Zealand, and the United States. This is important to note, as this is the first time that this amount of information relating to land and land tenure in American Samoa, which is spread across different hemispheres of the globe, has ever been comprehensively organized and compiled for consumption by the general public. But what truly makes the author's work special is that it is written from a perspective that has been lacking in this conversation. Up until now, academic discourse on the subject of American Samoan land and land tenure has been led by non-Samoans. This book is the first time that a Samoan voice has joined this discussion on the impact of American Samoan land, speaking from the perspective of a Samoan. Now, I want to make clear, I do not mean to infer that the Samoan voice should be the primary or the only authority on this issue, but rather what I wish to stress is that the only way to achieve a fuller understanding of these complexly layered issues relating to the historical interplay between the United States and American Samoa and the correlating effects on land and land tenure in American Samoa is with the inclusion of the Samoan voice. The author, through this book, boldly takes this first step of incorporating that voice into this discussion. Now, on a personal note, I've had the unique vantage of a front row seat to the development of this scholarly work, from fleeting idea to developed concept, to first draft, to polished final product. This book is the result of thousands of hours of research, drafting, and editing, all done in between having multiple jobs while raising 4 children and supporting her husband in his career. This book is truly the product of her fervent and faithful determination to share this knowledge with the Samoan people and the world. So without further fanfare, it gives me great pleasure to introduce to you the author of this extraordinary work, Dr. Lina Noe Nemea Kruse.
And warm greetings to honored guests, family, friends, and colleagues too numerous to acknowledge individually. It is truly an honor and blessing to stand before you today to present my published book, The Pacific Insular Case of American Samoa, Land Rights and Law in Unincorporated U.S. Territories, by Palgrave Macmillan Publishers. Thank you, Bishop Neil Annandale, for opening our event with a word of prayer. Paktai Telelawa, Va'afulu Brown, for your welcome and oration in the Samoan language. I am indebted to Alumni and Career Services, U.S. Relationships Manager, Taliana Posse, for graciously spearheading and organizing this book launch. The Alumni and Career Services is a bright light in recognizing the achievements of Brigham Young University of Hawaii graduates. Kaptai to David Ponormoana, manager of the Brigham Young University bookstore, for connecting me with Taliana and recommending that the bookstore carry the book for the community and its students. Many thanks to Dr. Michael Murdoch, chairman of the Political Science Department, for co-hosting this launch. Dr. Murdoch is at another college meeting right now. It has been a privilege to teach in the Political Science Department and learn from colleagues, in particular Professor Christina Akanoa and our students. Wakatai to my introduction to politics students for your beautiful siva. Appreciation to my husband, Vincent Kruse, for your heartfelt introduction of the merits of this book, but also for your support in order to complete the manuscript, which it was on time to the publisher. I am a Brigham Young University of Hawaii alumna. My parents, Joseph and Vernetta Mimea, are alumni of Brigham Young University of Hawaii. I was born at Kuluku Hospital. The first 5 years of my life, I lived on Malaikahana Beach, pole number 45, where my parents housed many students from Samoa, New Zealand, Tonga, and the Cook Islands, going to Church College of Hawaii, renamed Brigham Young University of Hawaii. Then my family moved to Hukilau Beach, where we live today. As a child, I took swim lessons here at the pool, as did many other children of Laie from Sister Ernestburg. I danced in hula performances right here in this very room under Auntie Sunday Maratanami. And I played ASO soccer all throughout my youth, practicing on those front fields. I was coached by Brother Ben Mihikali and Uncle Boise Kahalapuna. And now I am a political science instructor right here. This book launch here in my home, it means the world to me. The program is composed of my family members, whom without family and their endearing love and support, this book, I testify to you today, would not have come to fruition. Bishop Neil Annandale is my cousin. He hails from American Samoa. His parents, Uncle Neil and Auntie Losana, fed us, helped us when the storms repeatedly hit our home, and ultimately blessed my family with the pure love of Christ through charity when we lived in Lepuapua, American Samoa. Va'afulu Brown is married to my mother's first cousin, Taufi Brown, and they have been an integral part of our family for decades. The 4 political science students that were performing earlier, they are from my Introduction to Politics course. One of the dancers, the youngest one, Marita Fuyava, is my second cousin. From the village of Saniatu in Samoa. Saniatu is the village of my paternal grandmother, the village where the Church of Jesus Christ of Latter-day Saints has a primary school. Hakasnuka is the granddaughter of Telefonian Eka'aua, family that took in my mother when she came to Laie from Samoa to attend Church College of Hawaii. I am grateful to my parents here with us today, Joseph and Vernetta Mimea, for supporting me in this endeavor, even coming to live with us in American Samoa for a year to help care for my children and redline every chapter, draft after draft. Other authors, they asked their colleagues or they paid proofreaders. I have my mother. Thank you, Mom. My mother-in-law, Gail Kruse, hails from both American Samoa and Samoa. She is here as well, changing her flight so she could be here. And I couldn't be more thrilled. Gail Kruse and her mother, Adele Meredith, republished the book, History of Samoa by Brother Fred Henry. Gail retyped it, and Adele republished it as it was completely out of print. Adele felt that it was important to have an introduction to the history of Samoa in circulation. Ironically, I used this book in my doctorate thesis. For 6 years, I worked in the American Samoa Government Department of Commerce. I am the first territorial planner and manager of the Planning Division of Samoan Descent. When American Samoa was absorbed into the U.S. in 1900 as an unincorporated and unorganized territory, there has been only appointed and contracted foreign planners in charge of the physical planning that did not prioritize the protections of communal land tenure. Communal land tenure to them was not of value. The Planning Division is the sole arm of government responsible for the strategic long-term planning, infrastructural, urban and community, and zoning permits in American Samoa. I have seen firsthand through land use and zoning permits and village development projects in Tutuila, Aunuu, and Manua that make up American Samoa how in my professional work, the apportionments or the splitting of communal lands, how it truly does affect day-to-day life and culture in American Samoa. Once communal lands are converted, these parcels are forever severed from under the Matai authority and communal use. There is no longer access of cultural sites and spaces to use and practice among the family clans. Under Samoan custom, communal family land is owned by the Samoan family. As such, each member of the family has a right to use a portion of the communal land. The right of a family member to use communal land is a proprietary right within the Due Process Clause of the Territorial Constitution. Pule is the authority vested in the Matai to protect and conserve the family's assets and includes the power to divide and allocate land to individual members for their use. Under Samoan custom, the Matai has the duty to exercise his pule over communal property for the benefit of the family. When a family member surrenders their entitlement to use a particular portion of land, that parcel reverts to the Matai for the benefit of the family and may be exercised without limitation. A Matai may also evict a family member from communal lands for refusal to serve that Matai. Without communal lands, the Matai system is essentially powerless. Matai titles derive its authority from family clans. Family members regard their family having rights to communal lands under traditional village polity. As communal lands are converted, the Matais have less lands to distribute among family clans and fewer aggregate resources to perpetuate Fa'asamoa. Individually owned lands were judicially created and defined by the High Court of American Samoa. The High Court consisted of United States naval commandants, whom were the chief judge and governor at the same time. During this period, the territory was without the Republican form of checks and balances. It did not have 3 branches of government. When the United States Naval Commandant was appointed by the Department of Navy to oversee Tutuila's naval and coaling station, the Commandant was also assigned to the post of governor from 1902 to 1950. From 1950 to 1978, there were Department of Interior foreign appointed governors that expanded and also emboldened foreign property rights and even proposed, as I declare in my book, legal fiction without evidencing legal fact or precedent, that virgin bushlands belong to no one. All land in American Samoa before the arrival of the U.S. military were native lands, meaning family-owned communal lands under traditional Samoan polity. My passion, research, and boots-on-the-ground work filling the pages of this book is to protect the twin cornerstones of the Samoan culture in American Samoa against foreign land tenure that is not being regulated or monitored. Fa'asamoa is defined as the Samoan way of life, the embodiment of culture, language, tradition, and identity. Peter Tali Coleman, the first Samoan appointed and then popularly elected governor of American Samoa, described the twin cornerstones of the Fa'asamoa as being communal lands and the Fa'amatai system. The Fa'amatai system is the chiefly Matai system. Over the past 100 years, the apportionment of Samoan communal lands is not only unabated, but there is no regulatory system or statutory mechanism to prevent individually owned land tenure by being owned by non-Samoan, American Samoan ancestry. This is the main theme of my book, tracing indigenous land tenure prior to the mid-19th century when all lands in American Samoa were entirely native. Indigenous and Western land rights do not evolve in a vacuum. The historic treatment of the U.S. military in all 5 of the territories, coupled with the political and legal status determined only by the U.S. Congress, and the matrix of indiscernible U.S. Supreme Court decisions that may apply to one territory but not apply to another, may apply to several but not apply to all, is what I describe as ad hoc in nature. I have researched over 80 years of local law, ordinances, and policies in addition to U.S. Supreme Court cases over all 5 territories and affiliated states connected to the U.S. to highlight a few chapters of my book. First, I want to begin by challenging the existing legal discourse that individual land ownership existed in 19th century England. This is important because in every flagship outpost or colony and territory where English and American common law was codified, 18th and 19th century English legal writings of William Blackstone and Henry Maine are referenced in English common law as, quote, Blackstone and Maine, end quote. Every law school student that studies American or English common law studies Blackstone and Maine legal writings. However, what I argue in my book is before Blackstone and Maine, the English statute written by Henry III of England called the Ancient Statute of Merton, there only existed in England estates of land. Land ownership was in fact not permanent. The Crown did not award land in perpetuity. Power and control over the peerage system were developed to ensure the Crown had domination of all of its land holdings. And the purpose? It was a key demonstration of economic domination over its subjects. The United States naval commandants embraced the Blackstone and Maine legal doctrine that there existed individual land ownership, but completely failed to research the references that Blackstone and Maine cite, as they would have recognized the references in English law did not recognize such a land tenure by the king or codified anywhere in law. Therefore, justices appointed to the American Samoa High Court that applied Blackstone and Maine created a legal fiction. And the legal fiction is that virgin land that is uncultivated and unoccupied belongs to no one. There is no legal factual foundation going back to the law of Merton before Blackstone and Maine. I argue in my book, virgin land, uncultivated and unoccupied, belonged and belongs to this very day to the families of the district and under the stewardship of the Fa'amatai. Second, this book provides one of the first, if not the first, research of primary resources of naval cases to analyze the impacts that adverse land possession has had to the communal land rights. For the first time, identifies the adoption of adverse possession principles by the U.S. Naval Court. The Naval Court, they took that language from the 1899 Treaty of Berlin. The adverse possession principles and rights were readily adopted vis-a-vis Supreme Court cases adjudicated in independent state of Samoa without considering the impacts to culture, communal lands, or the deeds of cession. Adverse possession principles favor the possessor of land who is in, quote, open, notorious, actual, visible, exclusive, continuous, hostile, and adverse possession, end quote. I strongly argue in my book this type of land usage puts the legal onus on the landowner to prove ownership based on principles that requires usage. This is not so easy to do when visible and exclusive are contrary to communal lifestyle. In Western law, the strength of right to land claims is evidenced by continuous possession and occupation of land. In Samoan custom, customary land may be unused for cultural purposes, for agricultural and medicinal communal use, to buffer for natural resources, or cooking and burial spaces, or simply for the preservation of future family clans. In my book, I'm arguing that the Naval Court introduced adverse possession principles to decide land disputes. If someone lived on property belonging to someone else without permission, known or unknown to the true owners, for a certain amount of time, these squatters could claim adverse possession of the real property in court and take that title to land. At no time did the naval jurists explore the historical nature or extent of the communal land tenure, whereby unoccupied, vacant, or unused lands were treated and appropriated under the cultural, communal, or Fa'amatai systems. Samoa culture, it is oral, without written record or surveyed lands. Testimony in court by communal landowners were considered by naval judges as hearsay. The adverse possessors of land reaped the spoils of Western property rights. Adverse land possession has subsequently become a judicially sanctioned activity. Communally owned land can now be disentangled from the family and village, then owned as individually, just by living there with or without permission. The adverse land concept has created a judicial anomaly in the communal land tenure system. Land can now be taken from a family and owned by another person without permission or adherence to cultural protocol. To Samoans, the idea that land could be owned without consent from Matai or the village was unheard of before adverse possession. This unfamiliar type of land ownership and the individualistic notion of land rights birthed the system of individually owned lands. The Navy's intention of introducing adverse possession in American Samoa was to legitimize the ownership of privately owned land, a key principle of American democracy, completely incongruent to Samoa's custom and tradition. In 1951, when the Department of Interior took over administration, they continued expanding adverse possession rights, which ultimately, in 1970s, evolved to a completely new land tenure called individually owned lands. Third, I conducted quantitative descriptive research of all registered lands in American Samoa. In 1975, the Territorial Registrar recorded 1,441 acres as individually owned. By 2007, over 500 more acres had been registered as individually owned, totaling 1,962 acres. The total land acreage in the territory is 48,767 acres, of which 2/3 is physically inaccessible due to steep slopes and permeable land, primarily mountaintop land, leaving about 16,255 acres theoretically available. Of that available land, approximately 7,888 acres have been registered with the Territorial Registrar. Of the registered acreage, only 27% represents communal lands, and another 26% are registered as individually owned. In American Samoa, right this very minute, more individually owned land is registered than the entire government of American Samoa. The government has registered 20.9% of the total land. Conversely, 8,555 acres of land are not registered at all with the Territorial Register. I'm arguing in my book, if the American Samoa government and its people do not safeguard these remaining lands from being converted into individually owned, little land will remain for the government or communal registration. Fourth, I examined the U.S. Supreme Court's matrix of individualized laws termed the Insular cases. The Insular cases are Supreme Court decisions over territorial issues. The Insular cases define the constitutional relationship between the United States and all 5 of its territories. This is why there is no discernible, consistent legal foundation over any of the United States territories. The U.S. Supreme Court decided cases which is 2 schemes for insular territorial acquisition. The first is incorporated territories, where the Constitution applies on its own, and the second for unincorporated territories like American Samoa, only fundamental constitutional rights and privileges apply. Constitutional hawks, like the law firm Right Now engaged in the citizenship lawsuit in the Supreme Court, argue that relative to the full membership and equality that continental Americans enjoy, this unincorporated status has created inferior citizenship for insular non-citizen nationals. I argue in American Samoa's case, the unincorporated status of this territory works to protect the Matai, or as the Constitution describes it, a nobility system, and the communal lands, which could be considered as race exclusionary, as non-Samoans are not permitted to own lands. Fifth, I conducted archival research of all naval ordinances that advanced American principles, values, ideals, and ushered in a moneyed economy. During this time, the Navy forbade cultural traditions such as malangas when villages visit each other and host other villages. The Navy considered these traditions as unproductive and a waste of resources, primarily wasting of food and time. They forbade the gifting of pau-paus, which are small outrigger canoes for fishing, and they absolutely forbade free exchanges of food. During this time, the Navy mandated and regulated plantation cultivation in order to pay copra taxes that funded government coffers. This archival research explores the correlation between the naval's government's mandated cultivation and adverse possession growth of claims as a moneyed economy was entrenched in corporate taxes and production quotas.